Could I begin by saying I'm very grateful to Council for accommodating the court by allowing this later start, and we've agreed to make up for the time tomorrow morning.
I'm most grateful.
Thank you very much.
Good morning, my lord. If I could start with a little background information. The story in this case begins in 1967, when the European Commission issued the Postal Directive. That imposed on member states an obligation to provide a universal postal service, which would guarantee a specified quality of service at affordable prices throughout the member states' territories. And each member state had to appoint one or more universal service provider who would provide that service. And in 1977, moving on, the Commission promulgated the sixth VAT directive, the sixth directive, which came into force on the 1st of January 1978. And one of the functions of the directive was to regulate on a community-wide basis those suppliers which were to be exempt from VAT. And the sixth directive was replaced in 2006 by the principal VAT directive, and that rationalized and consolidated the amended directives, retaining the exemptions effectively from the sixth directive with a few word changes. We are concerned in this case indirectly with the scope and effect of Article 1321A of the Principal VAT Directive, which is to be found at MS page 890 and tab 14 of the Principal Authorities volume.
Did you say 390?
890.
Oh, thank you.
I apologise.
No.
And that tells us that member states shall exempt the following transactions: the supply by the public postal services of services other than certain passenger transport and communications services, and the supply of goods incidental thereto. And one sees just above that that it's exemptions for certain activities in the public interest. Now, if one then moves on from that to the TNT case, which is in the primary authority bundle at tab 30, it's page 1037, page 171 of the physical bundle, 1037. One sees the opinion of Advocate General Cocotte, and at paragraph 28, halfway down that page, one sees that as early as 2002, there had been a reference to the Court of Justice, that's page 1037, from Denmark, and the date of that can be discerned from footnote 7, which is further down, but it's 2002, where the Advocate General had been of the opinion that the exemption was limited to reserved services, that is to say, those which were reserved to the Universal Postal Service and which were in the public interest. The Danish postal case never proceeded to a decision of the Court of Justice. And the reason that was so was because the reference was withdrawn by the member state. And then if one goes back to paragraph 3 of the Advocate General's opinion on page 1033, one sees that there had already been a certain amount of dispute between different member states as to what the scope of that exemption was, to the extent that the spectrum of opinion ranged from agreement with the United Kingdom's practice to rejection of any exemption in a liberalised market. Consequently, it says, the Commission has already brought infraction proceedings against certain member states, in some cases because they don't apply the exemption, and in other cases because they extend the exemption too far. Now, the High Court referred TNT in 2007 And one appreciate that written observations of the various member states that wanted to participate were therefore have been available by October 2007. The hearing was in 2008. The Advocate General's opinion was delivered in January 2009, and the Court of Justice's decision was in April 2009. So to complete the picture, Zipvit's first claim was made by letter dated the 15th of September 2009 and related to services supplied between 2006 and 2009. And in April 2010, Zipvit made a further claim for supplies between October 2009 and March 2010. And those are at pages 393 to 414. And I'm afraid I've only got the electronic bundle reference at the moment. I'll try and put that right later.
Sorry, what were the pages again?
393 to 414 in the electronic bundle. So these claims in 2009-2010 were made in relation to supplies taking place against a background of, at the very least, substantial debate between the various member states, the Commission, and no doubt universal services providers such as Royal Mails as to what the scope of the exemption was. There is no warrant in my respectful submission for the suggestion which will be made to you that everybody thought these supplies were exempt at the relevant time. By 2003, following the Advocate General's opinion, standard rating was clearly a significant risk. And it was a significant risk, such a significant risk, that the Royal Mail incorporated, it now appears, in its general terms and conditions, a clause that if the supplies it made turned out to be zero rated, the customer was going to be obliged to pay VAT on top. Once the issue of the proper construction of the Postal Services exemption reached the Court of Justice, it had no difficulty in deciding that the exemption had to be restricted to supplies by the public postal service acting in its capacity as an operator providing the universal postal service. And for that reason, the exemption did not apply to supplies made in circumstances where the terms had been individually negotiated, or which were dissociable from the service of public interest, or which met the special needs of economic operators, as the court says. One could not, simply by looking to see who had made the relevant supply of services, determine whether or not that supply was exempt. One had to ask, what was it that the relevant exemption was seeking to exempt? And specifically, was it likely that in framing the directive, the legislators would have considered it necessary or appropriate to exempt such services when provided to taxable traders, given that the exemptions were for services in the public interest? So there was a lot more to the question than simply looking at the black and white words on the page. And the commissioners will seek to persuade you that there's, as they sought to persuade those below, that there is something fundamentally unfair in Zipvit seeking to claim the benefit of the standard-rated nature of these supplies. That, in our submission, is an extraordinary argument to advance. The commissioners were well aware of the debate. They should have been alive to the issues. They accept no responsibilities for their own failure properly to interpret the legislation. And yet they demand that taxpayers be treated as mere opportunists.
But presumably Zipvit could have called, if it took the view that it was standard rated for VAT invoice.
It did.
It did call for that.
In fact, it participated in a case to which I will bring you, which was added to your bundle at the end of last week, called the Royal Mail Group litigation.
So is this right? Zipvit, at the relevant time, asked for a...
Not at the relevant
VAT
time, but
invoice.
certainly later it demanded those invoices. When it was said to it that it needed invoices in order to make a claim, it asked for invoices, but invoices have never been provided. The Royal Mail refused to provide invoices, as we shall see, in that case when we get to it. And when you look at it, what the judge has so far decided as a preliminary issue is that a customer is not entitled to enforce the statutory duty of a supplier to issue a VAT invoice.
In fact, my question was going back to the time when you said the
Yes.
Royal Mail should have appreciated that.
As I understand
Presumably
it,
that's true of
it didn't
Zip-
ask for invoices as such from the Royal Mail
Presumably that
originally.
was true of Zipvit as well. You
Yeah.
had access to all the case law and the Advocate General's opinion in the Denmark case and so on.
There is, with the greatest respect, a singular difference between a trader who trades in vitamins and a universal service provider who is very much alive to the niceties of European legislation relating to its own particular supplies.
Yes, I see. Thank you.
But can you help? The invoices that were being sought, were they with a view to paying more money to the Royal Mail?
It asked for invoices. If the invoices had been provided, then one would have looked at what the nature of the invoice was. It was for the Royal Mail to provide a particular invoice in a particular form.
What was Zipvit seeking?
Well, the best of all possible worlds, of course. I mean, inevitably, Zipvit's going to be seeking the best of all possible worlds. But I shall come on to explain why it was that the nature of the legislation leads to the position that when you have paid a sum of money and that is all that your supplier demands from you, that sum of money which has actually been paid is the touchstone by which you calculate VAT. And if your supplier says, I don't want any more money from you, it's not in your position to say, well, here it is anyway. Now, there is no dispute between the parties that the supplies which were identified for the purposes of this hearing are standard rated. The service in question is called a mail media service, and the way in which it operated was described in the witness statement of Mr. Bailey, which is at page 443 of the electronic bundle for reference. We need not go there. And it's in part 2 of the appendix, tab 21, page 201. Again, I'm not proposing to drag you through Mr. Bailey's witness statement. Essentially, it was a service which enabled Zipvit to send advertisements by letter to specified addressees and for the recipients to be able to respond to those advertisements without paying postage on a reply. And the amount that was charged by the Royal Mail would vary according to various factors, including the volume of both the outward and the inward postings.
Can I just ask, we're told that this is a test case with an underlying value at risk of something approaching £1 billion. Is the underlying value at risk all arising out of transactions in which Royal Mail is involved, or even more narrowly, the mail media service, or is it a much wider underlying community of cases?
Of that, I have to say a number of things, I think. First, that the figure was given to us by the commissioners.
Yeah, okay.
Secondly, that it extends backwards over a long period, and the question will be evidence, of course. Thirdly, it does extend to a large number of other supplies, which would either have been made by Royal Mail in its ordinary capacity, or by Parcel Force, which I think is a division or was a division of.
But it is all part of Royal Mail supplies.
It's all part of Royal Mail supplies.
That's what I really wanted to know.
Yeah.
And therefore, presumably, although the thing won't have been investigated closely, subject to the Royal Mail general terms and conditions.
Yes. Although, of course, one's dealing with a long period over which those general terms and conditions will have varied.
Yes.
I noticed that in the more recent RM Glow case, the figure had diminished to 500 million. And no doubt there are many other figures in between which one could identify as being nearer the reality. But one just simply doesn't know.
It is simply an estimate.
It is. It is.
Thank you.
What I can show you is at page 469 of the electronic bundle, which is Appendix Part 2, tab 26.
My appendix part 2 doesn't have tabs. Do you have a...
Page 227.
Is it 169?
469.
469. I'm mishearing all the time. Thank you. Yep.
One sees an example of an offer to supply the service made by Royal Mail, which identified, if one goes down, a price of 26,639.25p, based on a price of £161.45p per thousand. Now, that price and others like it were paid by Zipvit at the relevant time and were really paid. Now, the Royal Mail treated these supplies as exempt postal services, which it should not have done. And at page 409, the last two lines on 469, it has the name, it's signed. Yes, of course.
It's the incorporation of the terms and conditions.
Yes, I mean, there is no doubt that the terms and conditions were incorporated.
Yeah.
So going back to...
Does that mean that rather than saying Royal Mail treated it as exempt, we should be saying both parties treated it as exempt?
Well, it's a demand from Royal Mail for a sum of money.
Or both parties treated the price as exclusive of VAT?
I'm not sure that even that much thought was given to it. Mr. Bailey's evidence varied on the subject between what I think he said.
No, I'm not asking about what the parties thought. I'm asking about the terms and conditions to which...
Well, the terms and conditions said that the price was exclusive of VAT. We know that now because of the bulk terms and conditions. But at the relevant time, the way in which Royal Mail treated it when it raised the invoice on page 409, which is at page 167 of that bundle, I think, was it issued an invoice. It issued an invoice. Some of those are zero rated, some of them are exempt, as one sees from the right-hand side of the invoice. Some treated as zero rated at the top, 4, then we get lots of E's and another Z, and then 4 lines from the bottom, there's mail media. Now, there's nothing wrong with that as a VAT invoice, apart from the fact that it identified the service as exempt and failed to identify the VAT chargeable. In all other respects, it identifies the service, the date, the price, and the person by whom it is made. Now, in due course, Zipvit's representatives drew those invoices and the shortcomings in those invoices to the attention of the officer who was appointed to consider the voluntary disclosures that Zipvit made claiming the VAT back. And it should have been an easy job, we say, from that for those to decide what the VAT was and how much was recoverable. Now, we now know, as a result of the very late introduction before the Court of Appeal of evidence on the point, that there was a provision tucked away in Royal Mail's bulk terms and conditions applicable at the time of these particular supplies, which had the effect that if a supply turned out to be standard rated, Royal Mail could demand a further sum from the customer to cover that. That's not exactly what it says, but it's at 695. It's at page 454 of the hard bundle.
695.
695.
Yeah.
It's 3.1 postage. Unless expressly stated and otherwise in the schedule, all postage and other charges specified in each schedule is payable by the customer exclusive of VAT.
Now, the customer's obligation to pay takes you to the payment provisions set out in the relevant appendix.
One goes backwards and forwards through these documents. They are a myriad of complexities.
Is it an obligation, an outright obligation to pay, or an obligation to pay on demand?
It would be in this particular case, it would be an obligation to pay against an invoice. Because the process for mail media was that an invoice would be raised on a monthly basis, and you've seen a monthly invoice. So the question which lies...
Where is that set out? I'm so sorry, but
if I might come back
my
to you
mind,
after...
It
yes.
might matter
Yes.
whether the obligation to pay is a freestanding obligation, if that is due, or one which is only triggered by a demand to pay.
Yes. If I can locate the relevant documents in the bundle during the course of the short adjournment, I'll do that. So moving on, the question we have here is whether, for example, the sum of £26,000 paid by Zipvit, which alone Royal Mail has ever demanded from Zipvit, should be treated as inclusive of an appropriate amount of VAT. Clearly, if it had stated it was inclusive or had been silent, clearly if it had been inclusive, the answer would have been clear. But what would be the position if either the contract was silent on the point, and what if the contract specifically provided us here that the sum paid was exclusive of VAT, if any? And we say that the answer lies in a proper construction of the VAT Act and the directive and has got nothing to do with what the parties agree. What they agree and do goes to quantification, but not to fiscal analysis. And it's simpler to see the point in the UK legislation, since the directive is couched, as it always is, in somewhat more opaque terms. But having seen the domestic legislation, one can then consider the European perspective in the light of that and assume and appreciate it is intended to have the same effect. One starts with the VAT Act Section 1, which is at page 867, and is tab 1 of the primary authority bundle. Section 1.1, VAT shall be charged in accordance with the provisions of this Act on the supply of goods or services, including anything treated as supply, and sub 2, VAT on any supply of goods or services is a liability of the person making the supply and becomes due at the time of supply. And then there are some limited exceptions to that, and one can see that 3 and 4 deal with what are called acquisitions and importations. Acquisitions are effectively imports from the member states, and importations are goods from outside the member states, where for protection of the revenue, the burden is placed on the purchaser, the customer, in certain instances. And we'll come back to that. Then if one goes on to section 2, which is over leaf, subject to the following provisions of this section, VAT shall be charged at the rate of 20% and shall be charged, A, on the supply of goods or services by reference to the value of the supply as determined under this Act. And it is section 19, which is the provision under the Act which identifies the value of a supply. And that's page 871. Section 19.1 for the purpose
Sorry, for those of us in the hard copy.
Sorry, it's tab 4, page 12.
Thank you. Thank you.
The value of a supply, says section 19.1, shall, as except otherwise provided by or under this Act, be determined in accordance with this section and Schedule 6. We need not worry about Schedule 6. This section is what operates. And for those purposes, subsections 2 to 4 below shall have effect subject to that schedule. Then 2, if the supply is for a consideration in money, its value shall be taken to be such amount as, with the addition of the VAT chargeable, is equal to the consideration. So that's how the VAT Act deals with the value. It identifies it in accordance with Section 19. And the VAT payable by the supplier is determined by asking what the consideration for the supply is, and then netting that down by the relevant rate of VAT. So taking the simple example, if the rate of VAT is 20%, the VAT payable on the supplier of consideration of £120 is £20, because the value for VAT is taken to be £100, and the VAT on that is then 20. There is no need for parties to identify VAT in their contract. The Act does that for them. What a customer pays a supplier, we say, is consideration, and that which is paid or payable must then be subjected to the operation of Section 19.2 in order to determine how much of VAT must be paid by the supplier to the commissioners. Now, the commissioners may seek to persuade you that Section 19.2 only operates where the parties have not made their own specific provision in their contract. But that is not the way in which the VAT Act operates. One has to take Section 2 with Section 19 to identify this concept of the value for VAT. And that, in the case of cash consideration, is done by Section 19, subsection 2. And that was neatly explained by Mr. Justice Lewison in a case called Mason and Boscawen, which is page 1011, which is tab 29, page 152 of the primary authority bundle. And that was a case where a landlord of agricultural land had opted to tax his land, which means takes advantage of the opportunity afforded by the VAT Act to treat a supply of land as if it was standard rated when otherwise it would have been exempt. And in such a case, Section 89 of the Act makes provision for an adjustment in the consideration payable by the customer. And one sees Section 89 at paragraph 14 of the judgment on page 1016. Where there's a change in the rate of VAT charged on the supply, there shall be added to or deducted from the consideration for the supply an amount equal to the change. And the usual case is where the VAT rate changes in the budget, but it also applies to options to tax. The question in Mason and Boscawen was whether the service of a notice to pay was in proper form for the Agricultural Holdings Act 1986, when it demanded a sum shown as rent inclusive of VAT. So the question was quite clearly, was VAT part of the rent, the consideration, or was it not? And if it were not, then the rent demanded would be overstated, and then the agricultural notice would have been invalid. And you can see that at paragraph 25 on page 1020, page 161. Paragraph 27, Mr. Justice Lewison refers to a decision called Hostgilt, where Ms. Hazel Williamson QC dealt with the way in which VAT operates, which is quite handy, and says that the supplier is obliged to treat monies received as comprising the price for the goods, the basic price, and the VAT element as well. This arises from Section 19.2 of the Act. So you've got to split what you receive into two parts. And then, having considered the various cases, the judge goes on to summarize the position at paragraph 52 on page 1027, which is 168. At the foot of that page, he sets out a number of different propositions. And his conclusion is that the VAT element is part of the rent, i.e. part of the consideration. And the reasons he gives for that include at little 5 over the page, on page 2156. There is no freestanding or independent statutory right to recover VAT. If that is not part of the rent, the landlord has no means of recovering it. Accordingly, says the judge at 7, the same applies when the landlord and tenant agree a rent at a time when no VAT is chargeable, but VAT subsequently becomes chargeable. What happens is that the consideration for the grant is increased. And that, in my respectful submission, is absolutely right. So as the learned judge decided, it is inappropriate to separate a payment of a sum of money made by a customer to a supplier into two parts, one of which is the real consideration and the other of which is the VAT. All of it is consideration. There is simply a statutory obligation on the part of the supplier to pay to the commissioners a sum of money which is quantified by reference to the consideration paid. That is sections 1 and 2 and 19. It need not, of course, be part of the sum which the supplier has received from the customer. It is not open to the commissioners to demand that the consideration be hypothecated to meet the VAT liability, nor is it open to the commissioners to demand, without more, that the commissioners pay over part of the price due to the supplier to them instead. The price is merely the means of calculating the VAT chargeable on the supplier. And the VAT therefore establishes a method for determining how much VAT is payable by the supplier. And having done that, that amounts both to the supplier's output tax liability and the taxable customer's input tax. And that can be seen at section 24 on page 872, which is tab 5, page 13 of the primary authorities. In section 24, apologies, one sees subsections 1 and 2. Subject to the following provisions, input tax in relation to a taxable person means the following tax, that is to say the VAT on the supply to him of any goods or services. And subject to the following provision, says subsection 2, output tax in relation to a taxable person means VAT on supplies which he makes. So in each case, it's the VAT on the supply. It's not a different element. It's not something for the customer and something else for the supplier. It's the same sum. And the VAT on the supply means nothing more than the sum required by section 1 and computed in accordance with sections 2 and 19. Now, both the directive and the VAT Act dictate that whatever the parties' contracts may say, it is a fundamental rule that eventually VAT is to be charged only on that part of the price which is actually received by the supplier. So whether or not the parties or one of the parties calls part of the relevant amount the contract price or the sum paid VAT, the final result is determined by applying the statutory rules to that which has been paid. And one can see that in the operation of two sections in the VAT Act, which regulates what happens to each party to the transaction in the event that the customer fails to pay the whole of the price payable under the contract within a specified period. And those are sections 26A and 36. Now, 26A is at page 879, tab 8, page 20. And this ensures that where a recalcitrant customer fails to pay the price for the services, he can't hang on to his input tax deduction. It sets a 6-month deadline in which he must pay the supplier. And if at the end of that period the whole or part of the consideration remains unpaid, the customer is to be taken not to have been entitled to credit for input tax in respect of the VAT that is referable to the unpaid consideration or part. One sees the relevant date is defined in 2, but we don't need worry too much.
Is the relevant date in broad terms the date of the supply?
Yes, it generally is, or if later the date on which the sum becomes payable.
So if you give credit, that postpones the running of time.
Yes. But you can't hang around having received the supply. It's only if it's later that the date becomes payable. But if all the sum is due at the front end, then in those circumstances, that's the moment at which VAT becomes payable. And if after 6 months from that date you haven't paid it all off, then that's the end of the matter. You have
If in
to
the meantime
repay.
you've claimed it.
You claim it and then have to
have to
repay it.
credit
You have to
it
make an adjustment in a
Yeah.
subsequent, probably by way of a voluntary disclosure. So the Act's recognising again that what the customer pays is consideration, and that the VAT which is no longer deductible is only the referable amount, requiring one to have regard to sections 2 and 19 again. And what the section does not ask is whether the customer paid the basic price in host gilt terms, or the VAT, but not the basic price. You can't change the position you're in as far as section 26A is concerned by characterising that which has been paid in one way or another. You go back and do your computation. Now, the mirror provision for the supplier is called bad debt relief and is to be found at section 36 at page 881, which is tab 9, page 22. And one sees again where a person has supplied goods or services and has accounted for and paid VAT on the supply, and the whole or any part of the consideration has been written off in his accounts as a bad debt, and a period of 6 months beginning with the date of supply has elapsed, 881.
Thanks.
He is entitled to make a claim on the commissioners for a refund of VAT chargeable by reference to the outstanding amount. And the outstanding amount is defined in section 36(3) as an amount equal to the consideration so written off. And then there are further provisions relating to what happens if there's a subsequent adjustment. If somebody pays a bit more. There's no need for the customer to become insolvent or for it to be clear that payment won't be received. It suffices that the relevant amount has been outstanding for the relevant period and that the supplier writes it off in his bad debt account.
Mr. Thomas, could I ask you a question about section 26A,
Yes.
where it says, as from the end of that period, will be treated not to have been entitled to credit for input tax in respect to the VAT that is referable to the unpaid consideration
Yes.
part. What happens if the contract says price element £10 and VAT element £2? And it's specified that the first £10 will be allocated to the price element.
The answer to that is in a case to which I'm now about to take you.
All right, can I finish the question?
Yes.
I'm sure you're ahead of me, but why couldn't it be said that the input tax in respect to the VAT that is referable to the unpaid consideration, in my example, if the £2 remains unpaid, is the entirety of the VAT?
Again, if I simply say that the answer to that is that what one is focusing on is consideration, not VAT, and that what one does is ask what is input tax referable to the unpaid consideration or part. And it's a question of how one arrives at VAT which is referable. And I say that one does that by reference to sections 2 and 19.
Right, but if you're wrong about that and the parties are able themselves to specify which part of the consideration will be referable to the price element and to the VAT element, would section 26A not mean that in a case where the VAT element remains unpaid, it's the whole of the VAT which the trader is disentitled from treating as input tax?
I would submit that that's not the correct interpretation of the section, and it would be inconsistent also, I would say, with Article 90 of the directive, which is where the provision from which these sections are derived.
Right, okay, thank you.
But the important point is that the issue actually arose, but in relation to 36, not 26A, But exactly the same issue was in play there in a case called Simpson and Marwick against the Commissioners, which is at page 1067.
And I'm terribly sorry, in the hard
Tab 32, page 208.
Thank you.
Now, this was a case of a taxable trader who'd made a claim under his indemnity insurance policy on his insurers, and they instructed solicitors on his behalf to defend a claim brought against him by a third party. And the solicitors sent an invoice for their services to the insurers for everything other than the VAT element of their fees, and sent what they called a VAT-only invoice to the trader. So they split the consideration into two parts, one of which they said was consideration, and the other of which they said was VAT. Now, the trader then failed to pay on the invoice which had been sent to him, and his solicitors then made a bad debt claim on the Commissioners, seeking to recover the whole of the amount covered by the invoice issued to the trader on the basis that it was all VAT. And the Commissioners, in a reversal of the position they've adopted in this particular case, rejected the proposition that the parties could identify the nature of what had been paid as VAT or not, as the case may be, and successfully argued that solicitors could only recover an appropriate proportion of the VAT. Now, the Court of Session arrives at that decision by construing Section 36, but that construction was driven by an appreciation that consideration in Section 36 had to be interpreted by reference to Section 19 as an amount inclusive of VAT, which of course is where we always start, and that there was no warrant for treating the sums outstanding and the ways the parties had done as being nothing but VAT. And this is paragraphs 25, 26, and 27, which are at page 1077 or page 218 for you, my lord.
Thank you.
And I rely especially on paragraphs 26 and 27, which identify precisely why the consideration which is received should be treated as partly including VAT, whatever the parties may say. The words outstanding amount at foot of paragraph 26 are defined by reference to the amount of the consideration or the extent to which the consideration has been written off, but as Section 19 makes plain, consideration is an amount inclusive of VAT. There is nothing in the text which gives any warrant for an exercise of seeking to identify the extent to which the amount is demonstrably all VAT. And then at the foot of 27, just below letter H, put shortly, Simpson and Marwick provided a taxable service for which they received partial payment of the consideration, and we have to say we cannot see any real basis upon which it is, whereon it is inequitable or contrary to elementary fairness that they should not be responsible in the normal way for the proportionate amount of VAT on the part consideration which they received. And then in paragraph 28 to 29, one sees that the upper tribunal sought for support for its decision in the decision of Elida Gibbs, to which I'll take you, and in particular paragraph 24, and then at paragraph 29, the second half, just above letter E, it says the case was not concerned with bad debt relief, although the Court of Justice noted at paragraph 30 of its judgment, Article 11C1 of the directive, that's the predecessor to Article 90, in terms which appear to us to be consistent with the interpretation of Section 36 advanced by HMRC. We are unable to find in the judgment in Elida Gibbs any proper support for the view that where partial payment of the consideration has been made by the customer, and that partial payment may be identified as payment of the principal sum, with the practical consequence the amount unpaid and written off may be identifiable as the VAT element, the taxable person is entitled to bad debt relief on the entirety of the element of consideration equivalent to VAT and a proportionate part thereof. And I say the same is true in the mirror image case in relation to section 26A. And what happened here was entirely consistent with the views of the Court of Session, albeit applied to section 26A rather than section 36. Now, it's true that Zipvit was labouring under the misapprehension that the only consideration it had to pay was that which it had paid, because it was under the assumption, this was the starting point until one got to the Court of Appeal, that the sums in question were inclusive of VAT. But even if it had recognised the real position, even if it had understood what the true position was, it would still have recognised that section 26A was engaged because more than 6 months had gone by since the date of the supply without Royal Mail chasing it for the additional unpaid consideration, and would for that reason have restricted its claim accordingly. So construing section 26A and applying the approach adopted by Simpson and Marwick by the Court of Session, the same conclusion will be reached, even though the parties may have thought that that which was paid did not include VAT. Zipvit had a right to deduct VAT because a taxable supply had been made to it for the purposes of its taxable transactions for which it had paid a specified sum of money. And assuming it had paid £100 out of £120, the 120 being the amount to which Royal Mail was entitled, originally it had been entitled to deduct £20 on the basis that the principal sum was £100 plus £20 of VAT, and on no more being demanded, section 26A would then have restricted its right to deduct that by denying it its right to credit for input tax in respect of the VAT that is referable to the unpaid part of the consideration. That is to say, what the commissioners would have you regard as VAT and nothing else. Because the alternative to that is to come to the conclusion that if the parties originally thought the supply was exempt rather than standard rated, it follows that the supplier has an obligation still to account for VAT, output tax, but the taxable customer has no right to recover input tax. And that analysis is fundamentally inconsistent with the fundamental policy of the legislation, which is that output tax and input tax are descriptions of the same tax from the respective positions of the supplier and the customer. And we can see this at work in my submission in the directive. But for this, one has to read 2 articles together rather than simply the one. And those are articles 73 and 78, which are to be found at page 887, or tab 12, pages 28 to 29. 887. So Article 73, which is at the foot of the right-hand column, in respect of the supply of goods or services other than referred to in 74 to 77, the taxable amount shall include everything which constitutes consideration obtained or to be obtained by the supplier in return for the supply from the customer or a third party, including subsidies directly linked to the price of the supply. So it's everything which constitutes consideration. And then Article 78 qualifies that. It says the taxable amount shall include the following factors: taxes, duties, levies and charges, excluding the VAT itself. So one starts off with everything which constitutes the consideration, but then one removes the VAT. Because if one asks why it is that a customer pays VAT to a supplier, it is not because he has an obligation to do so as a matter of law. It is because it is part of the price for receiving the supply. It's consideration. And that the directive functions in that way is apparent from the answer given by the Court of Justice in a case called Tulica, which is at page 954, tab 25, page 95 of the primary authorities. In that case, like this case, the supplier had charged consideration for a supply but made no provision for VAT. The facts are summarised on page 956 at paragraphs 10 and 11. Tulica and Mr. Plavosin concluded numerous contracts for the sale of land. Tulica and Mr. Plavosin made no provision for VAT at the time the contracts were concluded. Then there was a tax inspection, then they want to collect the VAT, and the question for the court is, were the fiscal authorities right to add VAT on top of the consideration, as they did when they assessed the taxpayer? Or should it have been treated as part of that which was actually paid? And the argument which was advanced by the Romanian government, which is very similar to the argument which is advanced by the commissioners here, is to be found at paragraph 30. In essence, it submits that in order to determine the consideration obtained by the supplier, since consideration has a subjective value, it is appropriate to base oneself on the intentions of the parties and to have the consideration consist in the amount that the supplier intended to receive and the purchaser was prepared to pay. In the present case, that amount equals the amount set down in the contract without any deduction for VAT. And that argument is rejected by the Court of Justice at paragraphs 32 to 43. And the reasoning of the court was based on Articles 73 and 78 and the decision in Elida Gibbs. And one sees at 33, in accordance with the general rule in Article 73, the taxable amount for the supply of goods is the consideration actually received for them by this taxable person. That consideration is the subjective value. That is to say, the value actually received, and not a value estimated according to objective criteria. And this rule must be applied in accordance with the basic principle of the directive that the VAT system is aimed at taxing only the end consumer, and we'll come back to that when we look at Elida Gibbs. And where a contract of sale has been concluded without reference to VAT, where the supplier has no means under national law of recovering the VAT claimed subsequently by the taxable authorities, and I'll come on to that, the total price without deducting the VAT as the taxable amount on which the VAT is to be so levied leads to a situation where it is the supplier which bears the VAT burden, thereby conflicting with the principle that VAT is a tax on the consumption to be borne by the end consumer. It also conflicts with the rules that the tax authorities may not charge a VAT amount exceeding the amount paid by the taxable person. Actually, it says final consumer in paragraph 24 of Elida Gibbs. And there's also a reference to case Goldsmiths, which I'll bring you to in a minute. Now, the court's conclusion was that it was not open to the fiscal authorities to add VAT to the price, save where the supplier had the right under national law to add a supplement equal to the tax. No, not the VAT itself, to the agreed price. And exactly what that would be and when that would be a matter of national law. But an example is, I submit, Section 89 of the VAT Act, the one that was troubling Mr. Justice Lewison and Mason Boscawen. But in every case, what is envisaged is an adjustment to the contractual consideration to arrive at the gross amount, including the VAT. And what is clear is that the court did not consider that Article 78 allowed the fiscal authorities to add VAT to the consideration to arrive at the taxable amount. Albeit if the commissioners were right that consideration in Article 73 and the VAT in Article 78 were separate items, that is precisely what they would have done. So Tulica, in my submission, is precisely in line with Mason and Boscawen.
But in this case, they made no provision for VAT,
Indeed.
whereas in the general terms and conditions, there is a provision for VAT.
Indeed it is, and I'll deal with that. And what, of course, the court concluded...
Sorry, just on
Yes.
that, why doesn't that fall within paragraph 37 of this judgment? In other
Well,
words, you
it
have a
would, but
stipulated
what one then
price
does is to add, say that the consideration is larger because you add the supplement back in, and it's a supplement equal to the amount of VAT rather than the VAT.
Right.
You start by increasing the consideration to take account of the amount which must now be paid. Because, as I say, what a customer pays is the price.
Right, but I mean, in our case, the price is the main consideration element plus the VAT. That's the effect of saying the price is exclusive of VAT and VAT being chargeable, isn't it?
But the whole of the amount is the price, not the price plus VAT.
Right.
What you've identified is a sum to which VAT must be added in order to arrive at the price.
Right. But, I mean, as a matter of national law, I'd have thought that the parties can stipulate which part of the price monies received will be allocated to first. So, in effect, they could say, and when you pay, what you pay off first is the primary consideration element, with more to come to cover the VAT.
That would leave the commissioners in a
sorry,
very...
just to finish my
Sorry.
question, that there doesn't seem to be anything in this case that says that that is incompatible, if they proceed in that way, that would be incompatible with any principle of EU law.
Well, apart from the fact that if one asked what it was that was intended to be paid in that case, it wasn't anything to do with VAT.
No,
It was cash consideration. There was no VAT there.
No, but which is what makes it different from our case, where there is the price is a stipulated sum of pounds, and on proper construction, the VAT element of 20%.
I absolutely agree, but there is a further step yet, and the further step yet is this, that if one reaches a stage where sections 26A, 36 are engaged, and you have identified what it is that has been paid and nothing more is paid, then the authorities tell you that you calculate the VAT by reference to that which is actually paid and not the sum which was originally stipulated as the contractual price. And you work out your VAT from that which is paid. And it matters not whether you call that VAT or not. It can't do, because otherwise the commissioners would be left in a very difficult position. If you get a supplier and a customer who decide that the price is going to be 120, but they've only paid 100, and they haven't paid the VAT, does one then say, well, clearly the supplier hasn't received any VAT, so how can he be expected to pay VAT on that? Stipulation by the customers proves too much. Stipulation by the parties cannot dictate the way in which the VAT Act operates. So where you find something which the parties did not think had VAT in it, if that turns out to be the price which is paid, or the price which is payable, you calculate your VAT on that so that the supplier ends up with a VAT liability. And correspondingly, in my submission, the customer who has paid that amount and not a penny moreover gets an input tax deduction, because it's that which is found in consideration. And so where one reaches a position that the court has left open the position where the supplier can recover a further sum from the customer. In that case, you calculate the VAT by grossing up the amount in question. Yes, that is so, but only so long as that amount remains recoverable from the customer. And in all cases, subject to the adjustment provision, the sections 26A and 36. Because sooner or later there is a cut-off date which is reached, at which you have to calculate what the input tax recoverable is and what the output tax payable is. And that is dictated by Article 90, Section 26A and 46.
So I think, can you just assure me that I've correctly understood you thus far? Leaving aside Section 26 and 36, the price in this case is to be ascertained by looking at the monetary sum in the quotation or the invoice, whichever you like, the 26,000 I think you showed us, plus whatever is in fact due under the general terms, conditions, obligation to pay that on top.
Yes.
And those are then not treated as differentiated payments for the working out of what the VAT is really due because of the Court of Session case.
Yes.
Yeah, okay.
So if one then turns to Elida Gibbs, which is at page 959, tab 26 of the authorities bundle, primary authorities bundle.
I'm so sorry, page?
959.
Thank you.
One can start at page 964. Paragraph 11. The case concerned money off coupons printed on the back of toothpaste packets or which could be cut out of magazines. We are only concerned with those which were being cut off the back of toothpaste packets. And the cashback coupon scheme mentioned in paragraph 11 was a procedure by which the customer bought the product from the retailer and then sent the coupon to the manufacturer, who would refund the amount stated on the coupon to the customer. And the manufacturer argued that its output tax liability in respect of the original sale of toothpaste to the retailer had to be reduced by the amount of VAT referable to the refunded sum. And the commissioners argued, and one can see this at paragraph 15 on page 965, 105, that the, sorry, I think it's 109, that the price could not be affected by a refund to the final consumer, and the Court of Justice decided in favour of the manufacturer. And in arriving at its decision, at paragraphs 18 to 24, the Court of Justice makes some general observations, which is at page 967. Where one sees both of the principles referred to by the Court of Justice in Tulica. And what those paragraphs amount to is a direction that one take account of the manner in which VAT is accounted for at each stage of a production distribution chain, and ensures that once the product reaches the end of the chain, the commissioners have in total received no more than the tax which is paid by the final consumer. So the final consumer's payment is a capping mechanism. Of course, the tax is not paid in any specific sense by the final consumer. If you were to ask most final consumers what VAT they'd paid on their pack of toothpaste, or what the VAT rate was, or whether they paid VAT at all, they wouldn't be able to tell you. But the assumption is made that the final consumer has borne VAT by paying whatever price he or she has paid for the goods or services. And because that is reduced by the amount which the manufacturer pays back to the customer, that reduces the total take that the commissioners can receive from this chain of production and distribution. And the court concluded that if the manufacturer reimburses part of that sum, the VAT paid by the final consumer is therefore reduced, because the final consumer has been repaid part of the price he paid to the retailer, even though there won't have been any mention of VAT in the refund transaction. One might have said that that which was repaid was all VAT and not part of the taxable amount. Or one could have said, well, it was all taxable amount, but no VAT. But neither of those arguments attracted the Court of Justice. So one reaches this rather odd position that the tax paid by the final consumer dictates the maximum amount of tax the commissioners can collect from persons further up the chain, even though the consideration under the manufacturer-retailer transaction never varies, and even though you could never know from which retailer the individual customer had bought the product. And so at paragraph 28, the court says it would not be in conformity with the directive for the manufacturer to account for VAT on more than he received after deduction of the sum repaid on the coupon, whether paid back to the retailer or the final consumer. And in support of that, at paragraph 31 sees the reference to Article 11C1, which is the passage to which the Court of Session referred in Simpson and Marwick. This comes about because of Article 90, Article 11C1, which, in order to ensure the neutrality of the taxable person's position, provides that in the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply has taken place, the taxable amount is to be reduced accordingly under conditions to be determined by the member states. And despite that, at paragraph 33, the Court of Justice says the retailer keeps his right to deduct the VAT attributable to his supply from the manufacturer, which demonstrates that the right of the intermediary to deduct input tax is computed by reference to the consideration he pays to the supplier, and is not computed by reference paid to the tax paid by the supplier to the commissioners. So it didn't matter to the court that the amount for which the manufacturer had to account to HMRC on the supply to the retailer differed from and was less than the amount that the retailer was entitled to deduct as input tax. So VAT need not be enforceable in order to be deductible. So the consequence of that is that one has to examine the entirety of the chain in order to see whether the commissioners have collected more or less VAT than paid by the final consumer. And the system works perfectly well as long as things are applied as they should be applied to the right rate of tax and so on. But they go horribly wrong as soon as there is a break in the chain because a transaction is incorrectly characterized for VAT purposes. And in the appendix to my case, I have given an example of what happens where there is such an error, and that's at page 102 of the electronic bundle or tab 6 of the core bundle, page 100. Now, the hypothesis is that there is a supplier S who makes a standard rated supply to R, who stands for the Royal Mail, which is then used by R to make a supply to Z, which is our Zipvit. Z uses that supply to make his own supply to a final consumer, S charges are £50 plus £10 VAT. And that service or good is then used by R to make the supply to Z, for which he charges Z £100. And the initial assumption of R is that his supply is exempt. So he doesn't seek to recover the £10 that S has charged him as input tax. Z then charges his own final consumer £150 for his supply, on which he accounts to HMRC for £25, because that's a standard rated supply and was inclusive of VAT, so it's £125 times 20% VAT. Now, adopting Elida-Gibbs, what HMRC ought to arrive at and end up with at the end of the chain is £25, because that's the VAT paid by the final consumer, but they do not. What they will receive is £10 from S plus £25 from Z. So this scenario is not in conformity with the directive. And one therefore has to address the alternative possibilities that there might be. And this one is possibility B. HMRC decide to leave matters there are not to collect the tax from R, and then one sees that that's how things work out. There's £35 paid. R accounts to nothing but won't reclaim input tax. Z accounts for £25 but is unable to deduct his input tax. And HMRC receives £35 even though the final consumer paid only £25. So the question is, how can one make the chain conform, or the tax position in relation to the chain conform? The easy way is possibility A, which is where everybody is put back in the right position. R then accounts to HMRC for £16.66p. He's able to deduct his £10 input tax. Z can then make his own £16.66p reclaim, and HMRC then ends up with £25. So that works. Possibility C is where R has included a provision in his contract with Z that the supply is exclusive of VAT, if any. And what happens if he then gets that money back from Z? In these circumstances, the figures go up. R collects £20 and accounts to HMRC for that. Z recovers that £20 and accounts to HMRC for £5 net. So HMRC collects £25 in all. And we're back to square one again. That's what should happen. The final possibility is possibility D, which is where R has the right to increase the consideration payable by Z, but HMRC decides for whatever reason not to collect it from him. He assures HMRC assure R that he doesn't have to pay it. Now, that cannot affect the characteristics of the supply made by R to Z. It remains a standard rated supply. But HMRC have decided not to collect the VAT from R, which means quite reasonably that because R has treated that as something in relation to which it's not going to account for VAT, he shouldn't be able to recover the input tax either. And that's the effect, the proper scope of two cases to which my learned friends will take you in due course, called MDDP and VDP. If you are making a supply which ought to be treated as standard rated, but you treat it as exempt, you may not, as the supplier, take the benefit of the exemption but also deduct the input tax on the supplies made to you. Now, if we pause there and assume that R2 have applied MDDP, the upshot is that the commissioners will remain in pocket because at that stage they'll still have collected £35. And the question is whether in those circumstances Z should be deprived of the VAT on the standard rated supply made to him by R. And there are two possibilities. And first, R sues Z on the contract and claims to be entitled to £120 on the basis of the standard rate of supply, even though the Commissioner said we don't want the VAT from you in any event. It's unlikely, but in those circumstances, it is, in my submission, crystal clear that Z must be able to get his £20 back. R has charged it to him. It's a standard rate of supply. He's paid it. He gets the VAT back. But there is a second possibility, and the second possibility is that R does not pursue Z for the extra £20 consideration. And in those circumstances, the total consideration on the RZ transaction drops to £100 because that is the sum actually paid by Z, on which, given that the transaction is standard rated, VAT of £16.66p accrues. And in my submission, there is no reason why Z should be unable to recover that input tax. The decision not to pursue R was a decision voluntarily taken by the Commissioners, which ought not and cannot R was a decision voluntarily taken by the Commissioners in my example, which cannot disadvantage traders further down the chain to the Commissioner's advantage. And that, in my submission, is consistent with paragraph 33 of Elida Gibbs. That merely because you've restricted the amount you're collecting from the supplier has no effect on the right of the customer to recover input tax. That is the Commissioner's choice, and they must take the consequences. And if they have, whether voluntarily or negligently, put themselves in a position where, say, by reason of representations made to R, they cannot recover the VAT from R, there is no reason why they should be able to alleviate their difficulties at Z's expense. The inability of the Commissioners fully to enforce the collection of VAT on R's supply cannot affect the intermediate trader. With which I can take you to Article 90 of the directive, which is the European equivalent of, or derivation of sections 26A and 36. Article 90 is at page 1215.
And I'm sorry, hard bundle.
I apologise. Additional Authorities, Volume 1, Tab 18. And this is what Article 11C1, which will be referred to in the relevant cases, became on consolidation into the Principal VAT Directive. And one sees it comes in two paragraphs. In the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount shall be reduced accordingly under conditions which shall be determined by the member state. And those are 26A and 36. And in the case of total or partial non-payment, member states may derogate from paragraph 1, and we'll see what the Court of Justice has to say about that second paragraph. So in my submission, it's clear enough that if the parties enter into a contract under which it is provided that if the supply proves to be standard rated, the consideration should be grossed up by the amount of the VAT, but for whatever reason the supplier does not pursue the customer for the additional sum, that is a case of partial non-payment and may involve a reduction in the price after the supply. And the formalities or lack of formalities required for the provision to be engaged were considered in two cases of the Court of Justice, both of which involved references from the United Kingdom. And the first is Goldsmiths, which is page 974, and it's tab 27 of the Primary Authorities bundle, page 115. And the facts of the case may be seen in paragraphs 3 to 7, a couple of pages in, 9, 7, and 6. presumably 117. It was a barter transaction between goldsmiths to jewellers and some advertising company, under which goldsmiths provided jewels in return for advertising services, which were to be in an amount around about £200,000. And it accounted for VAT on that £200,000 worth of supply. It received in return £67,000 worth of, £68,000 worth of advertising services from RRI, but then RRI went into insolvent liquidation and never provided any further services. And the question was whether or not Article 90, Article 11C1 was engaged in those circumstances. And the problem at the time was that United Kingdom law only then gave bad debt relief under its predecessor for transactions in cash and not transactions in kind. And the relevant part of the judgment is at paragraphs 14 to 16. Where the court asks whether or not the derogation provision allows the United Kingdom to exclude barter transactions from the scope of the adjustment provision. And one sees at paragraph 15 the emphasis on the basis of the assessment being the sum actually received. And the corollary of which is that tax authorities may not in any circumstances charge an amount of VAT exceeding the tax paid by the taxable person. And then it gets that from Elijah Gibbs, but of course it's got that wrong because it should have been final consumer rather than taxable person again. Goldsmith is probably the case where this final consumer taxable person issue first arises. And then paragraph 16 explains that Article 90 requires a member state to make provision for a reduction in the taxable amount and consequently the amount of VAT payable whenever, after a transaction has been concluded, part or all of the consideration has not been received by the taxable person. And then in paragraph 18, the court goes on to limit the scope of the derogation provision, effectively to cases where it's difficult to prove that the consideration has not been paid or was temporarily or only temporarily unpaid. And we say that sections 26A and 36 are the conditions determined by the United Kingdom. The United Kingdom has an obligation to allow or require the adjustment, but it is permitted to regulate the manner in which that is achieved. We now know that part of the consideration has not been received by the supplier Royal Mail. It follows that the commissioners have a duty to take that into account when determining the taxable amount and thus the correct amount of VAT, and therefore the correct amount of output tax and input tax. Zipvit has, as it happens, done that by restricting its claim to VAT to the VAT referable to the reduced amount of consideration it actually paid. But none of that is dependent on whether the sum in question was basic price or VAT. It's all dictated by the single question, how much is it that the supplier has eventually received? Once one knows that, one can calculate the VAT. The other case in this area is at page 1420, which is volume 1 of the Additional Authorities Bundle, tab 31. And the relevant passage is a short passage at paragraphs 1432, page 255.
Do you say 1422 or 30?
1432.
32.
1432.
Yeah. Yeah.
At paragraph 32, one sees the argument for the claimant and the Commission that in order to engage Article 11C1, Article 90, there has to be a subsequent amendment to the contract. And that's rejected by the Court of Justice in paragraph 33. The adjustment, it says, has to be made whenever part or all of the consideration is not received by the taxable person, whether or not there is an adjustment in the contractual relationships between the parties. And the Delighter gives us an example of that. So in my submission, the outcome from those two cases in Article 90 is whenever part of the price for a standard rated supply remains outstanding after the supply has been made, there comes a stage at which the directive acknowledges that it would be inappropriate for the consideration to include the sum not received, whereupon an adjustment is to be made by both the supplier and the purchaser. Those are prescribed in domestic law by sections 26A and 36. And so the additional consideration which the Royal Mail could have demanded from Zipvit, but it did not, falls out of account. And section 19.2 thereafter operates on the net amount actually received by the Royal Mail. And that then has to be treated as comprising both basic price and VAT. And the rights and obligations of the parties are determined by reference to that smaller sum. And what one doesn't do is to assume that one can throw all the carefully drafted rules in the waste paper basket simply because the parties originally believed the supply to be exempt. And essentially, Tulica deals with the case where the parties have not made provision for a further sum to be paid if the transaction proves to be standard rated. You find the VAT inside the payment made even though nobody thought it was there. But if the contract makes provision for the customer to pay a further amount in the event that the transaction is standard rated, one then has to ask whether that obligation is enforced or not. If it is enforced, then section 19.2 operates on the grossed up amount. If it is not, then Article 90 engages, and section 19.2 applies to the sum actually received by the supplier, which then takes one back to Tulica.
When you say the additional consideration that Royal Mail could have charged drops out of the picture, at what time does it drop out of the picture? Is it when it's statute barred as a contractual claim?
No, it's when section 26A and 36 engage, which is 6 months after the date of the supply.
But if it's not due until demanded, how does the 6-month rule work?
Well, I don't think anybody's really ever thought about that, but there comes a stage at which there comes a stage at which one has to say, if it's not been demanded, one looks at that which has been paid, and if it's never been paid, then it's not going to be paid. Whatever reason there may be why it isn't paid falls by the wayside.
And what about...
The consequence, my Lord, I apologise.
No, please, you finish.
The consequence, my Lord, of your analysis would be, well, Zipvit still is entitled to claim 20 because it's still exposed. It's not that it doesn't become entitled to claim anything. It becomes entitled to claim a larger amount of input tax, no input tax at all.
Yeah.
It never loses its opportunity of claiming the extra.
Well, at the moment, I'm just trying to see how it works without
Yes.
getting too bound up in the consequences.
Yes, yes. Yeah, absolutely.
And then, sorry, I just wanted to ask as a follow-up from mine. I follow what you say about Section 26A and Section 36, because that's the VAT regime having its own timetable, if you like, for claiming input tax. But the contractual claim would remain extant until
Yes.
the
Yes.
limitation period. So what would happen if after the 6-month period for Section 26A, Royal Mail finally wakes up and realises actually the price to be
And
paid
demands
should have
more.
been, and asks for the additional element?
There are adjustment provisions in the VAT regulations 1995 which deal with if you get more or if you... I mean, Section 36, I think, articulates that, and I can't remember whether Section 26A articulates it similarly, but there are provisions in the VAT regulations which make provision for upward adjustments as well as just allowing Sections 26A and 36 to operate in by themselves at the end of the 6-month period. So all is not lost. There can be subsequent adjustments in those circumstances.
How does it fit with paragraph 37 of Tulica, which says the situation is otherwise when the supplier has the possibility under national law of adding a supplement equal to the tax? That looks like the legal possibility rather than going into the bad debt provisions.
It doesn't. It does. It does.
So how does
in
your
those,
argument fit with that paragraph?
so far as that is concerned, one still has to apply Article 90 to the outcome of Tulica.
But
Once,
But it's different from Tulica. And what you're saying is you reached the position that there was in Tulica where no provision had been made to add on any further sum to cover the tax. You reach it
Yes.
at the point where the bad debt provisions click in. That's what you're saying, I think. But how does that fit with the wording of paragraph 37 of Tulica, which is dealing with... Because we're not in a Tulica situation.
would your ladyship remind me which...
Yes, paragraph, page 98 in the hard copy numbering. Paragraph 37.
957 electronic.
957. I'm obliged. There we are. And you're looking at paragraph 37.
37, because Tulica is a case where there's no provision for VAT, no option to go back to get some more money to cover the tax. Ours isn't, but you say it becomes like that.
It flows up and down in my submission. What happens is that if one is in a position that the taxpayer, supplier, who's got to account for VAT, can go back to his customer and ask for a larger amount of money, then the VAT which he has to pay is calculated by reference to the right to receive that larger amount of money. But if at that stage he doesn't go back and ask for the largest sum of money, but contents himself with the amount of money which he has already received, then one goes back, says Goldsmiths, to the position that one finds oneself in Tulica. It's not inconsistent with it, it's just looking at a timeline at which originally, if I'm entitled to ask for more money from my customer, then the answer is it's 20 on top of the 100. But Article 90 says, well, if you never collect that extra from your customer, it's 1666 again, and one's back to
The point I'm raising with you is that in law, the clicking in of the VAT bad debt provisions doesn't stop that debt being pursued. It just
No, of course not.
recognises a reality.
And
Tulica in paragraph 37 is talking about, I thought, a legal situation.
Well, it is, of course, talking about a legal situation, but only at a particular moment in time.
Right. Okay.
It's not looking at what would happen eventually as the thing gets worked out in practice. If, of course, one did have the demand for an extra sum of money at a later stage, then the adjustment provisions kick in again. And one then increases the amount of VAT which is due from the supplier to take account of the total amount which he has received. One starts from a position that VAT is chargeable by reference to the amount which is paid or payable. One then reaches a position that one looks back and say, well, what was it which was actually paid? And when one reaches the question of what was actually paid, and if that proves to be less than the sum which could have been collected, then VAT operates, says Goldsmith in Article 90, on that smaller sum.
I suppose it really depends on what otherwise means in paragraph 37 of Tulik. You're saying it doesn't mean that you go back to a subjective understanding that no VAT at all has been paid. It just means you calculate it in a different way by treating it as a smaller price.
Or a larger price.
Or a larger price, yes. I'm sorry.
You
yes.
recalculate it by treating the consideration as being 120 rather
A larger price, but then there will be another possibly exception to the exception if the extra wasn't demanded.
Just so.
Yeah.
So those are my submissions on the proper approach to computing the VAT and the taxable amount. And I can now turn to the question of the substantive right to claim to deduct input tax. And I'll start here with the European provisions with which most of the authorities are concerned. And one needs to have regard at the outset to four provisions, Articles 62, 63, and then 167 and 168. If we start with Articles 62 and 63, they are at page 886 and at tab 11 of the Primary Authorities Bundle, page 27. Now, Article 62 is a definitional provision. It defines a chargeable event as the occurrence by virtue of which legal conditions necessary for VAT to become chargeable are fulfilled. And Article 62.2 then says that the time at which VAT becomes chargeable is when the tax authority becomes entitled under the law at a given moment to claim the tax from the person liable to pay, even though the time of payment may be deferred. And then 63 takes those provisions and says that the chargeable event occurs and VAT shall become chargeable when the goods are supplied. So the time of supply is the time at which the VAT becomes chargeable, even though there may be a period in which passes before it gets paid over to the revenue. Now, moving on to page 892, which is tab 15. One sees Articles 167 and 168. And one sees that a right of deduction, this is your input tax right in UK terms, arises at the time the deductible tax becomes chargeable, which is where we started with Articles 62 and 63. And then Article 168 establishes the conditions which must be met if a trade customer is to be entitled to make a deduction of his input tax from the output tax which he has to pay to HMRC. And it's paragraph A that we are primarily concerned with. Insofar as they are used for the purposes of the taxed transactions of a taxable person, the taxable person shall be entitled to deduct the following from the VAT which he is liable to pay, and A, the VAT due or paid in that member state in respect of supplies to him of goods or services carried out or to be carried out by another taxable person. Those are the substantive conditions for deducting input tax on the making or receipt of a supply. And just to draw your attention to paragraphs C, D, and E, which deal with other VAT on importations and community acquisitions, where the VAT liability generally falls on the customer rather than the supplier, which we'll see at a later stage. So the debate between the parties, going back to paragraph A there, centres on that second substantive condition as to was there VAT due or paid in respect of the supplies to Zipvit of goods or services. And that comes back to the characterisation of the consideration which was paid by Zipvit to Royal Mail. And I say that by paying consideration in relation to a standard rated supply, it has to be taken to have paid VAT. And to that extent, Zipvit was entitled to deduct that VAT. And if, or to the extent that there was further consideration payable by Zipvit which was not paid, the VAT referable to that additional consideration was not deductible or ceased to be deductible because of Articles 90 and Section 26A. I should add this, that there is high authority at the level of the Court of Justice, which has frequently been repeated, that there is no need for a taxable person to have paid consideration to a supplier before being entitled to deduct. That's why it says paid or payable. Nor indeed is there any need to prove that the supplier has accounted to HMRC for the tax, or even has any intention of doing so. And the authority which we can look at in that context is an authority called Bonnick, which is at page 921, tab 22 of the primary authorities bundle. If I can just summarise the facts rather than getting into the detail, because it's a rather confused case. It was a case where the trader was seeking to deduct input tax on the purchase of wheat from two suppliers, A and B, and the Bulgarian authorities were of the opinion that A and B had never received enough wheat to enable them to make the supplies to the trader. It was all rather confused because the authorities appeared to accept that Bonnick had made the onward supplies and didn't suggest that they'd received the wheat from somebody else. So it was, goodness knows. But one goes to page 928, page 69, my lord. One sees how the court recast the question at paragraph 24. Referring court asked, in essence, whether the principles of proportionality, equal treatment, and legal certainty must be interpreted as meaning that in circumstances such as those of the case before the referring court, a taxable person may not be refused the right to deduct VAT in relation to a supply of goods in view of factors relating to transactions upstream of that supply, where the supply is considered not actually to have taken place. Then in paragraphs 25 to 27, the court stresses the fundamental and integral nature of the right to deduct input tax. And then at paragraph 28, it says the question whether the VAT payable on the prior or subsequent sales of the goods concerned has or has not been paid to the public purse is irrelevant to the right of the taxable person to deduct input VAT. And then at 29, in addition, it is apparent from the wording of Article 168A that in order to have a right of deduction, it is necessary first that the interested party be a taxable person within the meaning of the directive. Second, that the goods or services relied on to give entitlement to that right may be used by the taxable person for the purposes of his own taxed output transactions, i.e. uses them in the course of his standard rated trade. And thirdly, that as input, the goods or service must be supplied by another taxable person. That is it. Those are the criteria, according to the Court of Justice, which need to be proved in order to discharge the obligation to show that you've satisfied the substantive conditions for the right to deduct input tax.
It's not immediately clear from just reading 29 in isolation but they're saying those are the only conditions. I mean, I understand your submission that that is what they're saying. Is there a shortcut to scholarship in understanding that that's the correct interpretation?
No. One takes it as it is, I think. I know.
Right.
But there's no indication that there are further things that one then has to do at that stage. What one does get to at paragraph 40 on page 782, that's 930 of the electronic bundle, is the more general principle that a taxable person can't be refused a right to deduct unless he knew or should have known that through the acquisition of the goods in question he was participating in VAT fraud committed by the supplier or an upstream supplier. And that paragraph 43, that proof of that falls on the taxing authorities. So you've got a fundamental right to deduct input tax. You satisfy the substantive conditions. And if the national authorities want to bring in other justifications for denying you the right, having proved what is in paragraph 29, they have got to do so. So we say that Zipvit would have proved it had satisfied the substantive conditions for input tax recovery because there was evidence available to the commissioners provided by Zipvit as to which supplies were mail media supplies, what was paid by Zipvit for those supplies, the dates when those supplies were made to it by Royal Mail, and it's not disputed that Zipvit made use of those supplies for the purposes of its fully taxable trade. And the Court of Appeal savour its tentative conclusion on the position where the supplier has the right to demand further consideration from a customer when the transaction becomes to be standard rated, which it would have referred to the Court of Justice, was with the taxpayer up to that point. And for reference, that's paragraphs 85 to 90 of the decision of Lord Justice Henderson, which is page 160 of the electronic bundle.
160.
Yes, and I think it's tab 8, page 29 of the core bundle. Where the court, though, went wrong in my submission was when it turned its attention to the question of whether it was necessary for a taxpayer to satisfy the formal conditions as well as the substantive conditions for the recovery of input tax. So at this stage, I turn to the formal conditions. And one starts here with page 893 of the electronic bundle, tab 16, page 34 of the primary authorities bundle, my lord. Page 893 of the electronic bundle. (178A). In order to exercise the right of deduction, a taxable person must meet the following conditions. A, for the purposes of deductions pursuant to Article 16A in respect of the supply of goods or services, he must hold an invoice drawn up in accordance with Articles 220 to 236 and Articles 238, 239 and 240. That then leads one to Article 226, which is at page 897 and tab 19. And Article 226, which is the one which is in play, sets out 15 conditions which have to be satisfied by an invoice. Now, without more, one might assume that the consequence of failing the formal conditions was that one wouldn't be entitled to exercise one's right to deduct. That has not, in my submission, been the view of the Court of Justice, which has regularly rejected such a submission when made on behalf of national authorities. It's fair to say it has taken some time to arrive at that conclusion, and that the authorities which are before this court show a developing analysis towards the position where the Court of Justice has most recently plumped for the conclusion that a member state cannot rely on a failure to satisfy formal conditions as the basis of denying the taxpayer's deduction, provided there is proof that the substantive conditions for the right to deduct have been satisfied. What the formal conditions, such as those in Article 226 are hard objective evidence that that is so. But even when an invoice which fully complies with Article 226 is unavailable, it is still open to the taxpayer to make good his claim to deduct by providing alternative and conclusive evidence that Article 168 has been satisfied. Not only has the Court of Justice expressed this view when considering claims for input tax deduction under Article 168A, but it's also done the same, drawn this substance over form distinction in cases concerned with where the taxpayer is seeking an exemption for exports with a right to deduct input tax, and where a taxpayer has been obliged under the reverse charge process to account for output tax on the importation or acquisition of goods from another state, but doesn't hold a valid invoice at the time when it makes a claim on the commissioners to assert its right to recover that tax as input tax. In each of those cases, the court has concluded that to deny input tax when the substantive conditions have been satisfied would be to breach the fundamental principle of the neutrality of VAT and or the principle of proportionality. And the earliest cases in this area seem to have been reverse charge cases, and at page 867, sorry, let's pass on from that to 1265.
But we're still under the heading reverse charge cases.
We are. This is the reverse charge. I was looking in the wrong place.
And I'm sorry.
It's additional authorities, I think volume 2, tab 27. Yes, my lord, it is.
Additional authorities.
Volume 2.
It starts at 34, so perhaps it's one. Is it eco-trade that you're...
Eco-trade is the one. Is it? I apologise. So it is. This was a case where the Italian customer had received overseas transport supplies, where the operators had issued invoices which either failed to refer to VAT or had treated the transaction as exempt. And the Italian tax authorities decided that, in fact, the customer should have operated the reverse charge procedure. And the reverse charge procedure is a procedure which, under Italian law, required the customer to issue a VAT invoice to himself and then to set the output tax that he would have to pay on that invoice against the input tax, which he could then claim on that invoice. And that's seen at page 1289, page 112. Paragraph 5.
Could I have the MS number again, sorry?
1289.
1289, thank you.
There's the description of the reverse charge procedure. Then at page 1294, page 117, paragraph 19, one sees that Ecotrade had failed to do this It's a somewhat cryptic reference where it says that it recorded the invoices in the register of purchases but not in the register of invoices, which is code for failing to issue a VAT invoice for the reverse charge to itself. Now, the court then dealt with two issues, the first of which mismatched. Limitation periods is irrelevant, but at page 1304, page 127, it picks up the second question.
What was the page?
1304, my lady.
Thank you.
Paragraph 55 onwards, under heading the reassessment and recovery procedure practice. Paragraphs 55 to 57 are a narrative of the Italian position prescribing the necessary formality for issuing a VAT invoice. And one sees that at the top of the next page.
Yeah.
Follows from the application of such a formality that Ecotrade should have invoiced itself for the relevant transactions and record that invoice separately, together with the invoice issued by the supplier in the register of invoices and the register of purchases. So it would have a VAT credit corresponding precisely to the tax due. And the conclusion of the Court of Justice is at paragraphs 62 to 64. Essentially, the principles of fiscal neutrality require the deduction of the input tax to be allowed if the substantive conditions are satisfied and a failure to comply with those formalities by the taxable person cannot deprive him of his right to deduct. That's the end of paragraph 62. And then the reason for this is at paragraph 66. Although provisions allow member states to take certain measures, they mustn't go more further than necessary to obtain the objectives. Measures mustn't be used in a way which would systematically undermine the right to deduct VAT, which is a fundamental principle of the common system of VAT. Now, in Ecotrade, of course, the relevant formal requirement was issuing a VAT invoice at all. And despite that, Ecotrade should have been permitted to deduct, provided the fiscal authorities had the information necessary to establish that the trader was liable to VAT as a recipient of the services in question. That's the earliest case, I think, in the area. But it then gets picked up and used and applied in later cases. And the next one is a case called Paper Consult at page 1054, tab 31 of the Primary Authorities bundle.
Sorry, page?
1054.
Thank you.
We can go through to 1059, I think. Paragraph 21. What had happened was that a supplier had supplied services to the trader, but had been declared inactive by the Romanian tax authorities because they hadn't filed their VAT returns and presumably hadn't paid their VAT. And so the invoice issued by the supplier was defective, presumably in not having a VAT number on it. But certainly, could the customer still recover the VAT? And the Romanian government was clearly concerned that there was an unregistered trader issuing invoices to a taxpayer on which it was collecting tax, which might never be seen by the fiscal authorities because it wouldn't be making VAT returns, because it wasn't registered for VAT. And the Court of Justice's decision can be picked up at paragraphs 33 onwards. Under substance, that's at page 1061. And at paragraphs 34 and 35, the Court of Justice stresses the fundamental principle of VAT that a taxable person is able to deduct VAT due or already paid on goods purchased and services received. And then at 38 to 43, one sees the court drawing a distinction between substantive and formal conditions. 39 deals with substantive conditions, and it identifies what you need to do in order to have satisfied the substantive conditions. And then at paragraphs.
And sorry, what do you say about 38, where the court seems to say the right to deduct subject to compliance with both?
Well, that's because it's about to divide them into two, and 39 then deals with substantive conditions, and 40 to 43 deals with the formal conditions. So one sees at paragraph 40, as to the detailed rules governing the exercise of the right to deduct, which may be considered formal requirements or conditions, Article 178A provides that the taxable person must hold an invoice drawn up in accordance with Articles 220 and so on. According to settled case law, the fundamental principle of VAT neutrality requires deduction of input tax to be allowed if the substantive requirements have been satisfied, even if the taxable person has failed to comply with some of the formal requirements. The position may, however, be different, paragraph 42, if non-compliance with such formal requirements effectively prevents production of conclusive evidence that substantive requirements have been satisfied. And 43, similarly, it is settled law that the right to deduct may be refused when it is established in the light of objective evidence that that right is being invoked fraudulently or abusively. And those are what become the fundamental exceptions to the right of a taxpayer to deduct input tax when he has failed to satisfy all the formal conditions. If you can't prove conclusive that you've satisfied the substantive conditions, or there's fraud or abuse. And in my submission, that's what the Court of Justice is saying there, that those are the exceptions to the demand if you fail your formal conditions, which would have allowed you to prove that you had satisfied the substantive conditions. Nevertheless, you can still prove that you have satisfied the substantive conditions by another means, and as long as you do that, and there is no fraud or abuse concerned, there is no problem. Now, interestingly, at paragraphs 50 to 51, the Court of Justice emphasises that the commissioners may not require a taxable person to undertake complex and far-reaching checks as to his supplier. And then at paragraph 60, the impossibility for the taxable person to demonstrate the transactions concluded with the trader declared inactive must meet the conditions laid down by the directive. And in particular, that the VAT has been paid into the public purse by that trader goes beyond what is necessary to attain the legitimate objective pursued by the directive. So there, in my submission, the Court of Justice is identifying a complex and far-reaching check on which you cannot expect the customer to be able to give information. And if the commissioners were to be asked by a customer to tell them whether or not their supplier had paid the tax over to them, I suspect they would be met by a suggestion that they couldn't let them know because of taxpayer confidentiality. So a taxpayer is never in a position to know with absolute certainty whether his supplier has accounted for tax to the commissioners, and it therefore cannot be right, in my submission, for a customer's right of recovery to be dictated by the production of evidence in whatever form that such a payment has been made.
But am I right in thinking in this case the VAT has not been paid into the public purse?
But it can't be a condition that that be so, because
Right, but
the customer never knows.
So I was just looking at paragraph 60, where what was, as I understand it, found to be disproportionate about the particular rule in that case was that it would prevent the customer, is that right?
Making an application for input tax deduction.
Yes.
If you
By-
required
by
the customer,
showing that
yes.
his supplier,
Yes.
called here I think the trader,
Yeah.
had in fact paid in.
Yes. And of course, that's consistent with Bonnick, where Bonnick says you don't have to have paid, and the supplier doesn't have to have paid the tax in order for the tax to be deductible. That's res inter alios acta.
Although presumably in Bonnick's there was a perfectly compliant VAT invoice. Bonnick's, was there a perfectly compliant VAT invoice?
Well,
So that, if you like, the formal condition was satisfied.
there was a different, yes, but of course it was one where the fiscal authorities were saying whatever the invoice may say, none of that has ever happened. Bonnick, it was all about whether or not the wheat had ever been received.
Oh yes, I understand.
Yes. So it's all very well having a document, but the document doesn't necessarily demonstrate with absolute certainty. It offers objective but not subjective understanding of what may have happened. The next case is Cartrans. And this was, it says at page 932, tab 23 of the primary authority bundle.
I'm so sorry, I missed the tab number.
Tab 23 of the primary authority bundle.
Thank you.
We can pick it up at 937, which is probably 78 in yours, my lord.
Thank you.
This was a case where the trader was seeking to recover input tax on the basis that he had exported goods from the community. And before he could do that, he had to show that he placed the goods under an export procedure, and he had to produce certain documents in that regard, and those are shown at paragraph 20. And in this case, Cartrans couldn't produce the export declarations, which is paragraph 23. Now, it's fair comment, as paragraph 37 at page 940 makes clear, that the directive lays down no specific rules for the monitoring for the exemption of exports. But what paragraph 37 does go on to show is that when you exercise your power as a member state doing the same thing as the community does, member states must observe the general principles of law which form part of the European Union legal order, including legal certainty and proportionality. So you're applying the same principles again. And then at paragraph 38, as regards the principle of proportionality, a national measure goes further than is necessary to ensure the correct collection of the tax if, in essence, it makes the right to exemption from VAT, subject to compliance with formal obligations without any account being taken of the substantive requirements, and in particular without any consideration being given as to whether those requirements have been satisfied. Paragraph 39, when the substantive requirements have been satisfied, the principle of fiscal neutrality requires VAT exemption to be granted even if certain formal requirements have been omitted. And paragraph 40, according to the court's case law, there are only two situations in which the failure to meet a formal requirement may result in the loss of entitlement to an exemption from VAT. Paragraph 41, first principle of fiscal neutrality cannot be invoked for the purposes of exemption by a taxable person who has intentionally participated in tax evasion. and paragraph 42, second, a non-compliance with a formal requirement may lead to the refusal of an exemption from VAT if the non-compliance would effectively prevent the production of conclusive evidence of the substantive requirements of being satisfied. So there's a principle developing here in the different cases as to a substance over form condition. And there are a host of similar cases. The next one I'll take you to, which I think is probably going to be the last case before the short adjournment, is a case called Barlis, which is at page 898, which is tab 20, my lord.
Thank you.
And this is a case of input tax denial where the services were those of lawyers and the failure lay in not identifying what the supplies were with sufficient particularity or the period over which the supplies were rendered. One sees that at page 900, paragraph 15. And so at paragraph 16, Barlis itself provided further information, annexes giving a more detailed description of the legal services in question. And the question is whether or not putting those together, that was sufficient to entitle Barlis to an input tax deduction. And the court asks itself two separate questions. And the first question it asks itself is, did the invoices satisfy the formal conditions of Article 226? And this is paragraphs 25 to 35. One sees that in the heading just above 25. Then entirely separate from that question as to whether or not the formal requirements were satisfied, it asks a second question at paragraphs 36 onwards. What were the consequences of an invoice not satisfying the conditions required by Articles 226 and 227 for the exercise of the right to deduct? And the court says, assume the invoices didn't satisfy Article 226, 6 and 7. What is the outcome of that? And this is 36 to 49. And what we find is a repetition of what we've already seen. One has to satisfy the substantive conditions, but paragraph 42, the principle of neutrality requires deduction of input tax to be allowed if substantive conditions have been satisfied, even if you failed to comply with some formal conditions. So if you have the information necessary to establish the substantive requirements have been satisfied, you cannot, in relation to the right of the taxable person to deduct that tax, impose additional conditions which may have the effect of rendering the right ineffective for practical purposes. And those additional questions have, in my submission, to be the questions asked by Article 226. And at 43 to 45, they say if the tax authorities can't refuse the right to deduct VAT on the sole ground an invoice doesn't satisfy those conditions, if they have the information available, they can't restrict themselves to examining the invoice. They must also take account of additional information provided by the taxable person. And that's confirmed by Article 219, which treats as an invoice any document or message that amends and refers specifically and unambiguously to the initial invoice. And then it goes on to say, well, given all that, it is for the referring tribunal to take account of all the information included in the invoices and in the annex produced in order to ascertain whether the substantive conditions for its right to deduct VAT are satisfied. Now, oddly enough, I think that, I don't know that might be a convenient moment to break before I address what Lord Justice Henderson had to say about others.
That'd be excellent. Thank you very much. We will resume at 2 o'clock.